30082OM. This is Van Buren Township versus Lindsay Dineski.
Yes, ma'am, that's me.
On behalf of the people.
I'm sorry, ma'am. Say your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial in this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be a lawyer. I would not need that.
She stood up, clutching a bunch of crumpled papers like they held the key to everything, loudly declaring things like, "I do not consent to your jurisdiction," and "I am a free woman under natural law." The judge, clearly familiar with this type of courtroom drama, just watched in silence. Then came the twist. She tried to dismiss the entire court, stating, "This court is now in dishonor and hereby nullified." The room fell completely silent. Even the bailiff looked caught off guard. And just when it seemed like things couldn't get stranger, she launched into claims about admiralty law, flags with gold trim, and how her birth certificate is supposedly a secret contract with a fictional government. At this point, it was less about the case, and more about escaping what she sees as a system built on illusion.
That being the case, have you had the opportunity to speak to Ms. Manarino this morning?
Yes. I think all charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Dineski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial, but I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights, Michigan and federal rights under the Constitution.
And then, believe it or not, she claimed to have proof of her innocence and tried to present it right there at the arraignment. Now, if she's really studying law like she says, shouldn't she know the basics? An arraignment is just where you enter a plea, not the moment to start dropping documents like it's closing arguments. Evidence comes later, not in round one. Bit of a mix-up there, don't you think?
The recommendation from Van Buren Township, ma'am, is that they do not oppose personal bond, and that was going to be the court's intent. Set your bond at $5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Dineski, I understand that you have the defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In our interim, there's also a request that you have no contact with Charles Nerswick, Nerswick. Do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which is what I was actually calling the police about. And he has our child in danger, and they refuse to listen. And now she's gone. She's missing. So I will be countersuing Romulus, I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this.
As she continued arguing about her constitutional rights and claiming the court itself was illegitimate, the judge finally stepped in, calm and composed. He reminded her, "Ma'am, this is an arraignment. Claims about natural law don't apply here. You either enter a plea or we proceed." But instead of responding to that, she doubled down. Out came another pile of papers, this time filled with claims that the U.S. government is illegally taxing her and that she's somehow exempt from federal law altogether. At this point, the prosecutor looked visibly stressed, and the bailiff glanced for the exit like he was counting down the seconds. The courtroom was hanging on the edge of chaos, but she was still fully convinced she was about to expose a massive legal cover-up.
Erroneous charges, and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court in federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law, I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I could quote laws that Van Buren police broke. I They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls recorded. I mean, it would really be a waste of the court's time.
By now, the judge had clearly had enough. He responded firmly, saying something along the lines of, "Karen, you're in no position to lecture this court about wasted time, especially considering the stack of baseless lawsuits you filed, including ones against your husband and officers who didn't follow your version of the law." Then came a pointed reminder. The judge announced he was adding to the case a previously dismissed lawsuit in which she accused several Greene County officers of running her off the road, only to change her story once she started recording. Talk about a twist. She wasn't finished, though. She started citing federal statutes like 18 U.S.C. 241 and 242, claiming her rights were being violated. Classic sovereign citizen rhetoric. And of course, she threw in the all-too-familiar line, "I do not consent to prosecution." As if that alone could pause the entire legal system.
One who broke the law was Van Buren Township, not myself.
Ms. Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the first.
Yes, but I could ask for it to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren Township. His father used to be the fire, one of the high, he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for asking.
Honestly, it felt like she was never going to stop. And no offense, Karen, but the claim that police arrested you just for asking for help, that's a hard sell. Are we really supposed to believe that officers found you stranded and thought, "Let's arrest her for needing assistance"? That doesn't add up. If anything, what likely got their attention were the outrageous accusations and legal confusion she kept stirring up. It's as if she believed her sovereign citizen label somehow made her exempt from common sense or consequences. But declaring yourself outside the system doesn't mean reality won't catch up. Nice try, though.
Ms. Dineski, just so you're clear, this matter is being recorded and we're streaming live on YouTube. I only say that so that you may be mindful of the things that you say. Ms. Manarino, you were starting to say something.
Yes, Your Honor, as it relates to bond, I understand that Ms. Dineski has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Ms. Dineski having contact with him as it relates to the two children, the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Ms. Dineski, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her as he does as a biological parent.
Sorry, Karen, but here's the truth. Nurswick legally adopted that child, and that's a completely separate legal process. You don't automatically gain parental rights just because you believe there's a hidden agenda behind it. Yes, courts can consider visitation, but only if it serves the child's best interest. And based on your courtroom behavior and the conspiracies you've been pushing, it's hard to see how that standard is being met. Family law isn't about personal beliefs or theories. It's about what's healthiest and safest for the child. And from where things stand, it doesn't look like you're making a strong case in that regard.
When gave him custody, used me as a deciding factor as to why he got custody of that child. So that actually, just that particular statement shows that this is about him abusing myself and Haley and using the court as a shield to keep a mother away from a child. And the fact that he took her away from me, she's not been away from me more than 3 days since the day I met her. And he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues. Because when I met her, a bio mother had abused her and neglected her, and I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age, because she was so behind due to the abuse and neglect from Charles and the bio mother.
At this point, a clear pattern is starting to emerge. Karen consistently shifts the blame onto others, positioning herself as some kind of misunderstood hero. She paints the biological parents as the villains and portrays herself as the one trying to rescue the child from a broken situation. But here's the twist. While she accused the child's father of emotional abuse, she still chose to have 2 more children with him. That contradiction speaks volumes. And honestly, it's possible the best thing for that child right now has been the time apart. These past 2 months may have offered a rare sense of calm, a break from the turmoil and tension that often seems to follow Karen wherever she goes.
Kidnapped our child, and then used Van Buren police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren police and Charles Nerswick.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So
well, that's what I'm asking for the agreement, due to the fact I was not given any evidence. I wasn't.
Oh, and Karen, here's a quick lesson in discovery. It's that part of the legal process where both sides swap information and evidence before the trial even starts. You know, the thing they actually teach in real law schools. Maybe once you finish your studies at Fantasyland University, they'll cover that chapter. Until then, it might be a good idea to hold off on trying to rewrite the entire legal system with your self-taught, sovereign citizen theories.